Good evening. Honorable Justice Srimati Bharti Dangre Madam, senior advocates, seniors, colleagues, juniors, interns, and all law students, I, Siddhi Bhosle, welcome you all for today's lecture on behalf of Advocates Association of Western India. It is a great honor for AAWI to have Madam with us today to deliver the lecture on 3 new criminal laws. Before we begin, I request President Sir, Advocate Prashant Rayekar, to please welcome Madam formally.
Good evening, Honorable Justice Dangre Madam and esteemed members of the Bar. On behalf of AWI and in my capacity as the President of the Bar, I welcome you all for this today's lecture. We are honored to have with us, and it's our proud privilege that she is with us, a distinguished judge, Honorable Dangre Madam, whose expertise and insights are widely recognized and respected. Her ladyship will be sharing her knowledge on new criminal law, a subject that is both timely and relevant to all of us. We are eager to learn from her a vast experience in the field of law and exceptional perspective. Kindly join me with giving her a warm welcome to her ladyship, Justice Bharti Nyaya.
Before we begin with the lecture, we would like to felicitate Madam. So I request Advocate Gunjan Shah, committee member, to please welcome Madam with a bouquet of flowers. And Advocate Sukumar Ganwat to please offer Madam a small token of our appreciation. I would now request Dangre Madam to please address the audience.
Very good evening to each and everyone. And I must at the outset say that I was being told that this lecture is for the juniors. But good that we have seniors, so whatever difficulties which we have in reading the act, will get immediate responses to that. In fact, this is probably the second or third time when I am speaking on this topic. Initially, when in the month of May, I delivered my first lecture. At that time, it was at the outset, it was very difficult to understand which are the provisions which have undergone the change, where there is a substitution, which are the new provisions. And at that time, the task appeared to be really very Herculean. Of course, before that, there was brainstorming sessions at the parliamentary committee. Thereafter, various inputs were given. We had witnessed a lot of discussions on the television across various forums as to the necessity of passing these laws. The question that was asked, of course, there was a division in the two group of opinions. One group specifically feeling that we have good that we have done away with these anarchic laws, since they were so colloquial in nature that they had to be dispensed with one or the other day. The fresh school of thought who thought that these laws are very necessary propounded that it was a need of the day. There was another school of thought which specifically felt that what was the need for overhauling the whole system, because merely changing the arrangement in the sections, merely putting sections up and down, it has not made any material difference. And the moot question that was posed was whether this is really going to expedite the criminal justice delivery system. Now, ultimately, right or wrong, from 1st of July, we have brought these 3 legislations into force. There we have also started implementing it. We know it very well that whenever any new law is introduced, whatever may be on the statute book, when it gets translated into reality, then it creates a completely different scenario. And as we all know, we are still interpreting and struggling with that old Criminal Procedure Code 1973, interpreting the provisions of Evidence Act, and no finality is attached to it, because every time a new insight comes when we interpret a provision, and with reference to that a new interpretation comes, the section is looked at with a different way. Now this is we can say a newborn legislation, and definitely it will have its teething problem. Definitely there are some arenas where it differs from the earlier prevalent law, not a statutory provision, but whatever interpretation was received from the courts which has attained finality. One of the provisions which you all know which would be posing little difficulties like section 167, 167(2). Now therefore the question that arises before us, how do we actually practically implement these laws? We are still at a very nascent stage. Some provisions, if you find, I must at the outset tell you that the focus of these new laws is technology. The focus of these new laws is the interpretation which various earlier provisions has received. And in order to give effect to that provisions, it was deemed necessary that it should all be introduced in the new provisions itself. As far as the Indian Penal Code was concerned, of course, there is introduction of some new acts which amount to offences. CrPC, there is substantial change in the process. And after we go through these provisions, you will definitely agree with me that though we don't know how practically we'll be implementing it, but the intention of the legislature was definitely to enhance the justice delivery system. As far as Evidence Act is concerned, we are looking at the Evidence Act, which was so archaic that it never encompassed any provisions of the modern technologies. Then we had 65B, we were struggling with 65B. When you bring an electronic evidence, how would you deal with that evidence? All the while, a decade has gone when we were studying Shafi, then unless and until it got finalized by Arjun Khotpal. So these are all the trends which we have seen, but one thing we must all remember is this: law has to be developed according to the practicalities. Or actually, law gets developed when it is implemented. No matter what may be the intention of the lawmakers to make a law, to put it on a statute book in black and white, it always gets its color and life from the interpretation which is given by the judges. And between this law which is made and what interpretation we give it to it, lies that wing of the government, because here specifically we are going to deal with the investigating officers who have to first understand and implement these actual laws. Now it will be, of course, first the magistrates who will be dealing with this when the production comes before the magistrate, with what changes. So by the time a matter comes to the magistrate, he will interpret it in his own way. It comes to the High Court, and finally when it gets settled by the Supreme Court, we will have definitely a wide span of time. But one thing is sure, by going through the legislations, you will agree with me at the end of the lecture that the laws are intended for betterment and overhauling of the criminal system. Now, as I have already told you, that largely you will find that the law have focused upon the development, technological development. So much emphasis has been given on forensic science evidence, digital records, videotaping. This is something new technology which has been introduced. In addition to this, you will find accountability fixed on the police machinery also, because there are provisions in the Code of Criminal Procedure where you will find that the status of the and rather we can say that it is police accountability, at the same time making it more friendly to the victims. So there are provisions you will find in the Code of Criminal Procedure which provides that a victim or a complainant must be appraised of what development has taken place in his case, which provision was conspicuously absent. For reducing the pendency of the cases, now the district courts, the new bill provides, the new act provides to allow summary trials up to the offences of 3 years. So that gap of 1 year will definitely make a difference. In addition to this, you will find that there are timelines which are given at time to see to it that within this period the charge has to be framed, within this period the trial should be concluded. Once the judgment is closed and the matter is heard, within what period of time the judgment will be delivered. So these are all the procedures, these are all the sections which in fact enable and will speedify the procedure. This is what is expected. Most important is the significant aspect of the IPC is imposition of stricter penal punishments. You will find, because I will not be able to deal with each and every provision where the provision has undergone a change, because I think I was telling that it will be the attention span would be at the most 1 hour. After that everybody will get bored, but I must point to you so that when you are reading the provisions, you will specifically focus upon the change that has taken place because there are stricter penalties in form of punishments as well as in form of fines also. Because in the initial IPC, you would say that the fine was lagging from some 10 rupees, 50 rupees. Now there is increase in that. So stricter provision, this act also provides the punishment, stricter punishment are specifically provided in all those provisions which intend to safeguard the rights of women. Death penalty, which was always considered to be an archaic notion, and we all know how it has been interpreted. Now ultimately the Supreme Court, it has boiled down to the fact that it need not be, all chance should be given to see that there can be reformation. So though the sections prescribe, some sections have retained the death penalty, but we'll have to read it carefully. Sedition law, we are doubtful because 124A, now the Act of Endangering Sovereignty and Integrity of India, it has come in a different form, though not totally eliminated. So you will find that these are some of the significant aspects of the new legislations which make it, or we can say that it definitely is not the old wine in the new bottle, but we cannot also say that it is new wine in the old bottle. So anyway, that will decide, time will tell for us. Now we'll go by one as far as the IPC is concerned. I'll briefly take you the provisions of the Indian Penal Code, and I'll just point out to you where the changes have taken place so that it will make you easier for understanding. Now this Bharatiya Nyaya Sanhita 2023, which now replaces the Indian Penal Code, instead of 511 sections, comprises only of 358 sections. The definitions which are very pertinent and which were never included, IPC never had a definition of child specifically. Child, though we know that a child below 18 years, it has defined now, it has given a definition. Document is now given a definition by saying that which will include electronic evidence. Of course, we had that definition under the Information Technology Act. Now, one significant change is for the first time gender is defined. Now, gender is defined, the pronoun he and its derivatives are used of any person, whether male, female or transgender. This is keeping in consonance the Transgender Act of 2019. So, we have a definition of gender. Now, movable property is defined. Of course, in colloquial language as well as various other statutes have the definition of movable property. So, there is nothing much significant to note about. In the punishments to be prescribed, that is in section 4, in addition to death, imprisonment for life, imprisonment either of rigorous imprisonment, simple imprisonment, forfeiture, fine, one specific punishment is now introduced is community service. Now, community service has been specifically provided for 6 petty offences in the Penal Code. Now these are very petty offences. I mean, it's community service, so that normally you have seen that many courts, many a times while releasing an applicant on bail or sometimes have directed that you do this, you do that as a community service. But now it is made permissible to impose one of the punishment of community service. Now it is for 6 petty offences. This is like non-appearance in response to a proclamation, attempt to commit suicide, to compel or restrain exercise of lawful power of public servant, petty theft on return of theft money. In addition, you will find a section that is abet. Now one significant aspect of this is the 3 processes, that is attempt, abatement and conspiracy, are now brought under one chapter. So initially we had it scattered. So now this all comes under chapter 4, attempt, abatement and conspiracy. Section 48 is a very significant section which is newly introduced. It says that abatement and offence committed in India by a person outside India is now made an offence under section 48. This will definitely criminalize the act of those persons who sit outside India and conspire to commit an offence. So this is section 48. At this juncture, I will also point out to you one very significant provision in form of section 73 which is introduced, which is the act of printing or publishing any matter relating to court proceedings, and this will invite a punishment of 2 years and fine. So of course this unnecessary printing of any material, this has now been itself made as an offence. So these are the major changes as regards the offences are concerned. Another important changes now, if we go to the offence of section 57, it is abating commission of offence by public by more than 10 people, and this includes, this is not mob lynching. Mob lynching is a provision which is different, but this is section 57 which is specifically introduced. Now there was no definition of cruelty, though 498A defined by way of an explanation. It said that this would amount to cruelty, but now section 85 has specifically defined cruelty. Of course, it is something which was already provided by way of explanation to section 498A. But now there is a definition what would amount to cruelty. A new section is specifically added, that is snatching. Because earlier when you have an offence of chain snatching or whenever normal offences, you used to always put it in theft. Now there is a specific provision. Now it says that section 304 makes the act of snatching an offence in every part of the country which punishes the act of forcible seizure or grabbing of movable property. So different offences created. There is another new section that is in form of section 95, which provides that hiring, employing or engaging a child to commit offence is punishable with imprisonment of 3 years to 10 years. And if an offence is committed by virtue of engaging a child, then the punishment prescribed is what the offence committed would have invited. So this is a very significant provision. We will have to now study how it impacts the Juvenile Justice Act. But that act of engaging, because otherwise it becomes very difficult. You will find that most of the heinous offences we come across, which are committed by juveniles, and they can escape because they can't be punished, and they'll have to be go under the board and before the JJB under the Juvenile Justice Act. So this act itself made, and the punishment is also quite stringent, 3 years to 10 years. But if the offence is committed with the help of this person, then he will be provided a punishment which is equivalent to the punishment that is prescribed for the offence. Now, one important lacuna which we always face was cases of hit and run, because rash and negligent driving, 304A, minimum punishment prescribed. Now you have a specific provision in form of section 106(2), which addresses the issue of rising vehicular cases of hit and run. And this is now made punishable by prescribed that whoever causes death of any person by doing any rash or negligent act and escapes from the scene of incident without disclosing the incident to a police officer or magistrate shall be punished for a term which may extend to 10 years and with fine. So, much focus has been given because these are the cases, otherwise they escape. The perpetrators except by merely penalty of 3 years or something on the ground of rash and negligent driving. Now, another significant aspect of this act is definition of organized crime. Now, we had the MCOCA, now it will have to be seen how do we deal with it, because a state like Maharashtra, which had a specific enactment dealing with organized crime. Now, here section 111 itself defines what is organized crime. But you will find that all those safeguards which are provided in the State Act are conspicuously absent. There are no safeguards. You will only have a definition of what would amount to an organized crime. In addition, section 112 defines what would amount to petty organized crime, and section 113 defines the terrorist act. Now we'll have to really see that all those safeguards, because you had special enactments for this. Of course, as far as dealing with terrorism, UAPA, you had a central legislation, but an act dealing with an organized activity, we had the MCOC of state legislation. So what happens to these statutes will have to be worked out, because the statutes were so crafted that it had various safeguards, being very draconian laws. There were safeguards right from the point of view of the accused. Like you have so many exceptions, a statement of a co-accused when it becomes admissible under section 18. Now these three provisions are sans of any such safeguards. So it will have to be really seen how do the act and the provisions which are specifically contained in section 111 to 113 are going to be dealt with. We have not come across any cases, but we definitely know that as soon as they come, this debate on this is going to be ensued for sure. Now, 117.3 is another provision which provides stringent punishment for such acts of grievous hurt which results in persistent vegetative state or in permanent disability. And if the grievous hurt results into such vegetative state or permanent disability, then it will attract higher punishment for rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to imprisonment of life, with a special emphasis that remainder of that person's natural life. So all those cases where you find murder but raping a person, grievous hurt, which a person goes into coma, then it can be a punishment up to remainder of his life that is specifically carved out. New section 152 is also added in place of the sedition law. Of course, we will not go into this because you will find that there is very minuscule difference in these two sections. Though it is that the Supreme Court at time again said 120 has become archaic. Now the introduction of 152, we'll have to see how it can be construed. Now mob lynching, because many cases were coming and the Supreme Court had to deal, because it was not something which was to be dealt under 302, it was not simply murder, but it was a murder done with a particular intention, targeting a particular group of people. Therefore, section 103(2) has made a category of culpable homicide related to lynching, and it says that mob lynching is special categories that whenever such incident takes place or a murder and grievous hurt is caused by a group of 5 or more persons on the ground of victim's social profile, particularly his race, caste or community, sex, place of birth, language, personal belief, and any other grounds, without specifically using the word term mob lynching. So that is not defined, but murder and grievous hurt caused by a group of more than number of people prescribed, and which is targeted because they belong to particular sex, caste, place of birth, personal belief, because this is what we were witnessing for last almost a decade or so. So mob lynching, now the punishment that has been prescribed is minimum 7 years of mandatory imprisonment. So this is a deviation from the earlier law. Then you will find the 197(1)(d), the act of making or publishing false or misleading information which has tendency to jeopardize sovereignty, unity and integrity or security of India. This is made an offence which is punishable up to imprisonment of 3 years. There is grievous hurt which we understood under section 320. Now instead of 15 days, the number of days for which hospitalization should be required is now reduced from 20 days to 15 days. Initially it was 20 days, now it is met to 15 days. Now you will find that the terms which are repeatedly used like insane, lunatic, idiot has been done away. Like similarly British calendar, Queen, British India, they are all terms which are done away with. So we have made it quite friendly by removing all these terms. On going through all these provisions, you will find that largely the acts which amounted to major offences have remained the same. Some additional offences have been construed, some acts have been construed as offences, and except this you will find that as far as culpable homicide, whatever, there is no substantial change. So these are the only changes which have taken place in IPC. The focus is to see to it that what new type of acts which were otherwise amounting to offences, but we have to cover it either whatever are the provisions that are available, that is whether it is a provision of mob lynching, then rash and negligent driving. So you have to fit it in the particular provisions of IPC which were available, so you have enough different statutes. Now of course this will be prospective in operation, we don't have to tell that. Now we come to the procedure by which these acts are to be, or these offences are to be made punishable. And this enactment has definitely undergone large change in greater procedural aspect. Now, to start with, we all talk about bail, but bail was never defined. So for the first time we understand bail, and that is what ultimately has been included, that it is a means of release of a person accused or suspected of commission of an offence from custody of law upon certain condition imposed by an officer or court on execution by person of a bond or bail bond. So we all knew it, but this is added. Audio, video, electronic means is also specifically defined because we are largely focusing upon the electronic evidence, both in sense of Indian Evidence Act and the Code of Criminal Procedure. Bail bond are again defined. Electronic communication is given a specific definition. One in the definition of investigation, which includes all proceedings under the Sanhita for collection of evidence by police or any other person other than the magistrate. There is an explanation which is added and which is of great significance. It says that where any of the provisions of a special act are inconsistent with the provisions of this Sanhita, the provisions of the special act will prevail. Now, of course, we earlier had that section 4, subclause 2, section 5 saving when the provision dealing with the special act and the Code of Criminal Procedure. But in case for investigation itself, this is an explanation appended to the definition inserted. The definition of victim is little bit elaborated. Now, as far as the classes of courts are concerned, now we had those additional magistrate which is completely done away. Now there will be only judicial magistrate first class, judicial magistrate second class, the court of additional session and district judge. Now we'll have to see, because the powers are designated when a judge or JMFC is newly recruited, and you see that he is given this designation, but of course now necessary amendments have to be made. Except changing the nomenclature, ultimately the duties and powers which are interested have been maintained like that. So now you will have the judicial magistrate third class, metropolitan magistrate, because we will be seeing in Mumbai, and the assistant session judges, these posts are abolished. So the metropolitan magistrate which are peculiar to Mumbai city will have to be redesignated now. So there will be only now 4 categories of judges. Now, of course, the powers of the special executive magistrate, how they shall be conferred, that remains the same. One substantial and very significant change in the Code of Criminal Procedure is the establishment of a comprehensive directorate of prosecution. Of course, we had it, but we have not seen it to be in much action. The directorate prosecution was there, but it was not tasked with any obligation or any accountability. Now, by section 20 of the Act, a comprehensive directorate of prosecution, and it has defined the eligibility, functions and the powers of various authorities. And specifically, the director of prosecution will be responsible for giving opinions for filing appeals and monitoring cases punishable with 10 years or more with life imprisonment or death. And then you have a deputy director of prosecution who will have control over the prosecution below these sentences. So this is going to assist the prosecution wing to a greater extent, because you find sometimes for a long period of time it is undecided whether appeals are to be filed, and you see so many lacunas which, because of lack of opinion or lack of specific things being put before the court, you see that the magistrates or the judges act according to their own whims and fancies. Sometimes they are not able to get the assistance of the proper assistance from the prosecution, and we know the results, what happens when the matter comes at the appellate stage or when it goes to the Supreme Court. So to tackle with this, there are specific posts which are created with the designation of the Director of Prosecution and the Assistant Director of Prosecution, with accountability being fixed. They should give specific opinions. So this is a very significant change, and we'll see that this is going to bring about a lot of improvement in the prosecution side specifically. Now, section 23, the power of limit of imposing fine by magistrate of first class offences against children, acid attack, counterfeiting of coins and currency notes, human trafficking, and offences against state. If you look at it carefully, probably everything is covered. But of course, we'll have to now deal with what the Supreme Court said long back ago in D.K. Basu, or all other judgments which say that what are the rights of, not D.K. Basu, the earlier judgment which said that handcuffing is not permissible, and the officers have been punished if they have resorted to such a practice by specifically holding that it is violative of Article 21. It affects the dignity of a person. So Once again, the law will have to be relooked, because though the categories are specifically worked out, but probably it will cover large of the categories. Section 50 provides for immediate seizure of offensive weapons. Then it also prescribed that immediately, without delay, the accused should be forwarded to the medical officer and the report should be furnished to the IO. Now, technology compatibility has been introduced at this stage. Now, any person who is arrested, any seizure panchanama which is carried out, including the spot panchanama and all that process which the investigating officer is likely to be carried out, now they are to be videographed. Now, for some period of time, definitely we will be struggling with whether there was any past possibility of tampering, because we really don't know. We now see when you go on the streets, you'll find that when you are challan, you will get that police officer who comes to you with a small mobile, click your picture then and there only. But then if you go by the technology, the analogy of 65B, which is primary evidence, which is secondary evidence, then there will be a lot of jumbling, whether it will be special devices or whether production of that mobile phone, or if from that mobile phone the data is transferred into the police station and thereafter from a CD or a pen drive which is produced before the court, then who will be issuing these certificates, declaring its authenticity. So this will, as and when we come, will be dealing with this. One very significant aspect about which I think the other day the Honorable Chief Justice of India was also speaking was about to introduce the provision of gender neutrality under section 66. Initially it said adult member of the family. Now it says that adult member of the family for service of summons shall also include some adult member, which means initially it was some adult male member, but now it is some adult member, so that even a female is now competent. So look at the chair. So when we say that we have made it more friendly with the Indian scenario, this is what we aim and intend at. This is now a long time this was being looked at as stereotypes, so now we have a change. So even a service upon a female shall be considered to be a valid service. Now, section 82 casts a duty upon the police officer making arrest to forthwith give information regarding arrest. This is of course the principle of DK Basu, and the place where the arrested person is being held, to the designated police officer and to such police officer in another district where the arrested person normally resides. This is a change, subsection 2. This is that when a person is arrested at a different place, then where he is detained, where thereafter he is taken to, and whose custody is given to. Because sometimes you know that if he is in the prison and his custody gets transferred, the concerned police station officer sometimes is not aware that he was transferred, because some application is made, and in case of series of offences which arise out of the same transaction, you will find such a thing. So you have a specific provision in 82 subclause 2. Proclaimed offender, there is a change, because earlier a person could be declared as proclaimed offender under few sections, and heinous offences like rape, trafficking, etc. were not covered under this category. Now the significant change is in 84(4), where it is provided that a proclaimed offender can be declared in all offences which are punishable with imprisonment of 10 years or more, or with life imprisonment or with death. So every offence beyond 10 years, he can be declared as a proclaimed offender. Electronic evidence, of course, there is digital evidence which is introduced in form of section 94. Now, one significant provision is section 107, which is a new provision. Now, this is to enable the police, with the permission of the court, to attack and forfeit any property obtained as proceeds of crime. Now we have dealt with such type of, we have such a similar project, like for example we have it in PMLA, but there you have a 3-tier system. Under MPID, firstly an objection permission for an objection to be raised, then at a second tier a show cause to be given, after it is confirmed, then finally the final attachment order. But here we really wonder, because the section is very peculiar, section 107, and it is wide power given to the magistrate, but it will have to be really seen what are the, because the magistrate has a very limited means of ascertaining what is the title, what is the cause, who is the owner of the property. So this provision, we don't know whether it will be clogging the magistrate with too much of power, which will make it difficult for him to implement. Because this is very broadly worded. It says that where a police officer making an investigation has reason to believe that any property is derived, obtained directly as a result of a criminal activity or from commission of crime, he may, with the approval of Superintendent of Police or Commissioner of Police, make an application to the court or the magistrate exercising jurisdiction to take cognizance of the offence for attachment of such property. Now, clause 2, because PMLA we are seeing that reasons to believe has looked at crowned with such a power. Now we know that because of this we have judgments which say that reasons to believe there must be clear disclosure of the reasons to believe. Now this subsection 2 says if the court or magistrate has reasons to believe, now this is, imagine this is a court of the magistrate also, whether before or after taking evidence that all or any of such properties are proceeds of crime, the court or magistrate may issue a notice upon such person calling upon to show cause as to why the order of attachment shall not be met. Then subsection 3 says that where a notice issued to any person specifies any property as being held by any other person or such person, copy of the notice shall also be issued. On considering the explanation, if any, to the show cause notice and the material fact available before such court. Now who will bring this fact before the court? And after giving reasonable opportunity being heard, may pass an order of attachment in respect of the properties, proceeds which are found to be proceeds of crime. So this is going to definitely pose a lot of difficulty because we really don't know what is the infrastructure which the magistrate really have on practical aspect to find out. So there is only one tier system which may pose some difficulty, but of course, time will tell that how this procedure, how these provisions are interpreted or how what wording is attached to these provisions. So this is a completely new procedure. There are some changes in the maintenance aspect, but that will not go into. Another important significant is filing of zero FIR. This is now introduced in the code itself because all the while we have the process of filing zero FIR, but now one section 173 itself provides that when information is received by the police that discloses commission of an offence outside the limit of a police station, it shall be entered into the book to be kept by such officer for the purpose of lodging of information. Now, very interesting provision is the provision of registering an FIR. Now, 154, whenever a person comes to the court of law, FIR to be registered, information given of a cognizable offence. Now, there is a specific provision, it says that now the change in section 154, what we call as 173 now, it specifies that if information is received from any person through any electronic media, which says that without prejudice on receipt of information in relation to commission of any cognizable offence, which is more punishable but more, sorry, this is not the provision. The provision categorically says that when the information 173, subsection 1, subclause 2, when the information is received by electronic communication, it shall be taken on record on being signed within 3 days by the person giving it, and substance thereof shall be entered into a book which is kept by such officer in such form as the state government may prescribe. Now, what if a person has witnessed a murder taking place? He makes a phone call, but the FIR is not registered. FIR gets registered only when he comes and signs that complaint, and if the person doesn't come. Now, we'll have to see, because ultimately it's the interpretation, because this is the only addition as far as your first portion, 154.1, which said that every information relating to cognizable offence, irrespective of the area, may given orally or by electronic communication to officer, but this is a proviso which says that he should come and sign it. Now, what is expected? Whether the police officer shall wait till the person comes and sign it, because it says then only it will be entered. So this may pose some difficulty, but of course, if a wider interpretation is given to it, then of a cognizable offence, then there is nothing which prevents the police to take cognizance. But this says that unless he comes and signs it within 3 days, its entry shall not be taken. Now, another introduction, new provision is on receipt of information relating to commission of any cognizable offence, which is made punishable for 3 years or more, but less than 7 years, the officer in charge of a police station may, with prior permission of an officer not below rank of deputy superintendent, considering the nature of this. So this is as far as 7 years is concerned, because all we know the all line of judgment until then earlier, I think, Arnesh. So they said that it should not be just because you have the power, you will not exercise the power, but you will exercise it with great caution. So this is a provision now which will ensure that all those offences below 7 years, every accused is not automatically getting arrested. To add accountability for the investigating officer, 174 also in addition prescribed, the police officer, apart from referring the complaint to the magistrate, shall also forward the daily diary report of such cases to the magistrate fortnightly. So just to have the investigating officer and the magistrate work in unison. Now the new provision is in form of credibility, adding credibility to the investigation. The forensic experts have been mandated to visit the crime scene to collect foreign evidence for all offences punishable for 7 years or more than that. Now, but we don't have a mechanism presently. Like we in movies, English movies, we largely so know all those clocks with all those machineries and all. So we intend to do that, but the wait is for 5 years. Because it says that the time has been given for 5 years to implement this provision, being conscious of the fact that we know it very well that when the material goes for analysis for the chemical analyzer, specifically the forensic science laboratories which are authorized by the state government, it takes days, it takes years, and sometimes because of this we know what are the results. So keeping that in mind, we expect that in the next 5 years, all the states will be geared up for having this forensic evidence, to have the criminal investigation recorded in such a fashion that we will probably be matching up to what are the investigations that are taking place in foreign countries. But this is a step that if it is really implemented, then it will become very easy, because we all see, and all of you are practicing in criminal courts, understand the difficulty, because this spot panchanama, everybody only relies upon what that Havaldar or what that writer of the investigating officer has written. It's not the investigating officer who goes and actually sees the site. He will write it as per his understanding, referring one door here without explaining that there is another door there, and you keep on wondering all the while that if this was the entry, where was the exit from? So this has posed a lot of difficulty. So this will make the procedure very easy, so that this material will be carried up to the Supreme Court till the last level when an appeal is being heard. And the spot panchanama, the inquest panchanama specifically, seizure, because in many cases you find that this will do away with a very difficult scenario, that after so many days, if these articles are not available for identification, then it becomes very difficult, because the judgment say that it is not merely exhibiting a particular panchanama is not a proof of its contents. It will not amount to substantive evidence unless and until the witness in the witness box is confronted with these articles. So now, even if the articles are not retained, probably can probably dispense with all those muddemal properties which are preserved for years together, they get deteriorated. So if you have this articles videographed with a proper certification being issued, then it may ease all that pain which has to be taken to establish and prove these discoveries. The most significant aspect is of 167. Now 167, it categorically said, now I must confess that when I delivered my lecture at the Bombay Bar, I was really troubled as to how will we deal with this provision, which now, but since with the presence of all the learned senior counsel, it can be simply looked at. If we read the provision, we have seen that from time to time the interpretation that was received in respect of the custody for 15 days was interpreted in Anupam Kulkarni to mean the police custody of first 15 days. Now, a time had come, subclause 2 of section 167 being interpreted saying that the police will be entitled to avail the custody for first 15 days. But now there is a substantial change and it says in whole or in part. But very interesting thing which we can notice is about, if we look at the wording of this section, and then this is now the new section is 187. Now one fact I missed, because as I told you, it's not that we are very experts in law, and therefore whenever, as and when we keep on reading the provisions one by one, and no matter how many times we read it, we'll look at it in new perspective. Now 187 2, it says that this is procedure when an investigation cannot be completed in 24 hours, the heading remains the same. But that subclause 2 is now modified. Now what does it say? The magistrate to whom an accused person is forwarded under this section may, irrespective of whether he has or has not jurisdiction to try the case, after taking into consideration, now these are the wordings which are also newly added, whether the such person has not been released on bail or bail has been cancelled, authorize from time to time the detention of the accused in such custody as such magistrate thinks fit, for a term not exceeding 15 days in the whole. Now there is addition, or in parts, comma, at any time during initial 40 days or 60 days, out of detention period of 60 days or 90 days, as the case may be. Now, when I first delivered my lecture, I was really pondering as to how it would be transferred. In the sense that if the custody is available for first 10 days, 5 days is remaining. Now he comes in MCR, he makes an application for bail. He is released on bail. Now what would be the procedure that would be followed if he has to be again given the police custody? But then after careful reading, if we read subsection 2 with this wording, whether such person has not been released on bail or his bail has been cancelled, that means he is in judicial custody. So this, if we read, we don't know again, and many facets may come before us when we read this provision once again. But it makes the provision, because this is also these words are also added by the new amendment in this section. So now this makes it clear that whether such person has not been released on bail or bail has been cancelled. So that means he remains in judicial custody either on these two contingencies. It is then only in these circumstances the remaining period of police custody can be availed for further investigation. This is because in Senthil Balaji, the Supreme Court has said, it has expressed some doubt about Anupam, a peculiar case where 14 days the accused was in the hospital. So police did not get time to investigate. So the custody was not available even for barely for a day. And then the Supreme Court doubted Anupam that it requires a relook. But that relook, that issue which has been referred probably doesn't get answered, because here the person who is not released on bail or whose bail is cancelled means he remains in judicial custody. So as and when we keep on reading all these provisions, we don't know what new ideas, with what new perspective we'll be looking at them, and ultimately it also depends. In criminal law, we all know, we will construe a provision. Of course the provision remains static, but according to the practical situations which appear before you, you get an opportunity to interpret the provision, because we see various interpretation on particular provision, because the circumstances which we are dealing with on 190 taking cognizance, which we are still struggling. You have judgments and judgments repeatedly depending upon different situations and scenarios that appear before the court. So this is all about the most significant change. Then there are some victim-centric procedure which specifically provide that the victim shall be kept intimated, the charge sheet shall be supplied to the victim online, much emphasis is on the electronic evidence. We will have to again ask a question to ourselves, are we really equipped to implement these provisions in its entirety? Because charge sheet, if you have to send a charge sheet to an accused, you will not send it on its WhatsApp, surely. You will have to have some device, or a mail ID. Otherwise, how do WhatsApp can't be a mode for this thing? So of course now we know that every person has a mobile phone, but still we will have to make advanced technology and make specific provisions, because we all know when we are now we are using all those devices in the court also. Sometimes at some points we have suffered the glitches and the whole system comes to a standstill. The idea, in fact, if you look at the whole and when you read the debates which took place, the idea was that once a charge sheet is filed in the competent court, this charge sheet should be transmitted in all modes. So whenever it goes to a public prosecutor's office, so when a public prosecutor is arguing a matter, he don't have to ask the IO to get me the charge sheet. So all that papers of investigation in relation to that particular CR are available digitally, so that whether it's in the trial court, whether in the High Court, whether it's in the Supreme Court, now this procedure becomes very simple. When the charge sheet is there, the evidence recorded is digitally recorded. You have all the evidence in form of forensic evidence, which is also digitally recorded. What is required is just to compile it together. No matter, then we will be doing away with this all RMP being prepared, paper books being private paper. Sometimes we say private paper book without them. So it takes time for preparation of paper books, and that delays the trial. So that's with an expectation and hope that this will all be very smooth sailing. But looking to the paraphase which we are going through specifically for the judicial infrastructure, it definitely, because we alone cannot do anything. It is at the investigation level, and then it comes to the court of law. So definitely it's another decade for us, if we are too optimistic, to have the provisions completely implemented. Now, as far as the CrPC, the Evidence Act is concerned, there are no, because evidence ultimately amounts the same. The manner, what should be treated as evidence, what are relevant facts, how relevant facts would be proved, that has not undergone any change. The change is only as regards the manner in which the evidence, that is introduction of what you call as electronic evidence, and therefore you have an expanded definition of evidence which includes now electronic evidence, that is any information given electronically, and this also permits the appearance of witnesses, accused, experts to depose their evidence through electronic means. Now, for that purpose, if you are recording the evidence digitally, definitely you will have to maintain that much of space to store it. Digital space we are talking about. And digital space, we really don't know when we are those who are operating those on these iPads now. When we started with it, it was enough data. Then every month you get a warning, this has expired, enhance. So a time will come that whatever we had in this, we are going to pay a price for this. So ultimately, when we are going to store this huge data, either on iCloud or unless and until the state government gives us a different space in the digital in the digital cloud to store all the data, because ultimately the question will also be of its authenticity, the chances of it being tampered, and ultimately if there is some glitch occurs, where does the data go? So we definitely cannot, though the Evidence Act all focuses on everything to be done digitally, that all evidence also to be recorded digitally, unless and until we are really equipped to have proper safeguards for maintaining this data, we are really doubtful. Of course, now what we are doing presently is paper. As I am seeing, I am reading this and I am reading the paper also. So now we are not very sure about this. So presently we have the file. There are not that we are not recording the evidence, but by way of a safeguard, we have the backup in form of the paperwork also. So one day probably will come when we assume that we will be paperless. But I don't mean when we say paperless, it's only the Supreme Court and the High Court which is paperless. The whole system has to be paperless, because it doesn't be, I for myself, for my court, if I say that I give me all those papers online, though I may be in a position to do it. But unless and until you see that the entire procedure, because criminal justice system is something which goes into stages. And it is not only that we are involved, but it also involves the police machinery. And that's the great difficulty. But of course, now you'll find that we have all started that as far as the recording of charges, recording of evidence also in some cases, that has made the process very easy. But at the same time, we are always fearful in mind whether this would be considered as a conclusive proof of a particular circumstance or the fact which is to be proved before the court. And unless and until we are sure of the safeguards by which it was recorded, then it will be very risky. The courts will be having second thought whether to rely upon such evidence. Because we have seen cases now, as normally we notice that the machinery, police machinery or the investigating machinery is getting smarter with the invent of technology. but we are also at the same time noticing that the accused persons or those who are dealing in crimes are smarter than the system. So therefore we see so many cyber crimes being registered, difficult to track. If you I don't know how many of you have read the book about that the digital era, and this book, it will say I think the name of the book is Darknet, and if you read that Darknet, then those who are operating computers, those who know who are digitally working on this file, we really feel fearful as to, it's not what they say that Google and what we are operating is just a superficial layer. Below that, it is so deep down, we are not aware of that. So if that is the source, then we really wonder if we go for a procedure like this. But of course, we have to be no reason why should we not optimistic. And of course, some technology can be developed by which the whole data can be safely saved without any tampering. And it will be easily accessible right from the person who files the complaint, the victim, to the accused, his counsel when he is at the trial, when he goes in appeal, until the time when his appeal is out. I think the attention span, I could see that it has lasted for more than 15 minutes. And I'm really grateful and thankful to all of you. Of course, this is not only, I mean, if you have to, I just gave you a broader idea so that when you look into specifically for the junior lawyers, so that when you are looking, because otherwise when you look at the new enactments, you feel horrified that, oh my God, it's going to be so complicated. But there is no complication, it's very simple. And I think you have a website by the National NCRB itself, where you have these acts given along with the comparison. They have given it in a very beautiful manner. This is the website of NCRB Sankalan. Now you have all the acts given with the changes in different color shades so that it becomes easy. You can immediately notice what are the changes and how it has differed from the earlier statutes. I am very grateful to you. Thank you very much.
Thank you, madam. I'm sure this lecture is going to be of great help to all of us. I now request Suresh Sabrat, Sir, Secretary AWI, to kindly give the vote of thanks.
Honorable Civil Justice Dangre, respected seniors, and my dear friends, it really gives me pleasure to officiate vote of thanks for today's lecture series. Shri Krishna says to Arjuna, in this world, there is nothing as purifying as knowledge. Madam, it's really good start for our committee, since under our tenure we have begun the first lecture series by your leadership, and henceforth many more such lecture series will be held. Today's lecture on the new criminal law has been a journey of profound learning and insight, expertise of leadership, thorough analysis of the new criminal laws, and the comparison of the old new acts have illuminated the complexities of the new laws, making them accessible and understandable. Your leadership dedication of sharing knowledge is truly commendable. I am sure today we have all learned a lot on the new criminal laws. On behalf of the association, we are very much thankful to my lady for having spent considerable amount of time from the busy schedule. We are also thankful to all the respected seniors and friends for having attended this lecture series. Thank you once again.
We have also made preparation for some snacks, so everyone is requested to please have snacks.